So it really is the entire panoply of what could constitute a disability in an individual to ensure that they have appropriate and necessary access as someone who doesn't have that disability. And fundamentally, a great idea. I think we could all agree. The challenge is, as part of the statute, the Americans with Disabilities Act, it creates what are called private attorneys general. And by that, I mean it enables private attorneys like myself to bring suit under the act to enforce its protections, but to recover attorney's fees and costs in doing so. And so that's really what's brought us to our discussion today, Darren, is that we have a whole host of these private attorneys general, individual attorneys who bring these suits primarily to secure fee recoveries, not necessarily because they have an altruistic intention.
Welcome to CREPN Radio for influential commercial real estate professionals who work with investors, buyers, and sellers of commercial real estate coast to coast. Whether you're an investor, broker, lender, property manager, attorney, or accountant, we're here to learn from the experts.
Welcome to Commercial Real Estate Pro Network's CREPN Radio. Thanks for joining us. My name is J. Darren Gross. This is a podcast focused on commercial real estate investment and risk management strategies. Weekly, we have conversations with commercial real estate investors and professionals who provide their experience and insight to help you grow your real estate portfolio. Today's interview is sponsored by Building Insurance and Risk. When you invest in real estate, it pays to work with a real estate investor protection specialist to protect yourself and your investment from catastrophic loss. The experts at Building Insurance and Risk focus on real estate investor protection. They provide you with multiple insurance coverage offers and a side-by-side coverage comparison. To learn more, go to buildinginsurancerisk.com. Today, my guest is Josh Bauchner. Josh is a partner in the landlord, tenant, and litigation practices at Mandelbaum Barrett PC in New York. He brings a depth of an experience and dedication to his practice where he's involved in complex commercial litigation and class action lawsuits. And in just a minute, we're going to speak with Josh Bauchner about the Nuisance ADA Lawsuits. But first, a quick reminder, if you like our show, CREPN Radio, there are a couple things you can do to help us out. You can like, share, and subscribe. And as always, we encourage you to leave a comment. We love to hear from our listeners. Also, if you want to see how handsome our guests are, be sure to check out our YouTube channel. You can find us on YouTube at Commercial Real Estate Pro Network. And while you're there, please subscribe. With that, I want to welcome my guest, Josh Bauchner. Welcome to CREPN Radio.
Thank you very much for having me. I look forward to our conversation today.
Well, I'm delighted to have you, and likewise looking forward to our conversation. But before we get started, if you could take just a minute and share with the listeners a little bit about your background.
Sure. I've been practicing attorney for a little over a quarter century now. It always concerns me when I start measuring things in decades and quarter centuries, but I'm at that point in life. Primarily litigation, New York, New Jersey, although the practice does stem across the nation. And as an aside, I also chair our firm's cannabis, hemp, and psychedelics practice group, because as I'm sure you know, that's rather an emerging area of the law as well. But we do a lot of work in the commercial real estate sector, litigation work. It's the circle of law, right? So my colleagues on the transactional side put together these brilliant agreements, negotiate terms, and make a lot of money for people. Someone misplaces a comma, and then they sue, and we do that. And then everyone settles. We put together another agreement. Someone misplaces a semicolon, and then they sue, and on and on and on. So that's basically the day job. But I really enjoy it. We've got a great firm, great clients, and a hot topic to discuss today.
Awesome. Well, if this gets into other aspects of kind of real estate, nuisance type stuff, I'd love to hear about that as well. But specifically, the topic, the ADA claims. I can't remember what was the act that was passed. I mean, it was back in the 80s. I want to say that the the Americans with Disabilities Act that was passed
That's
that
right.
created
Yes,
the.
sir. I
So
apologize.
yeah,
Go on. American
well, no,
Dis-
I was just going to ask you. So, in its basic form, can you kind of provide some sort of context as what the law requires?
Sure. The Americans Disabilities Act was passed with the intention of ensuring access for people with disabilities to any place of public accommodation, which is really anything other than a private home. And so whether you're an actual public venue, for example, a courthouse, or a private business, but a restaurant, a hotel, a store, where there's the expectation that the public will be needing to gain entry, access your premises, the ADA applies. And in the broadest landscape, it is intended to ensure, for example, that there are ramps in the event that there are otherwise steps so that someone in a wheelchair can gain access. It provides for example, in a restaurant situation, that there's sufficient space between the tables so someone can navigate through. I'm sure you've seen most places have a handicapped bathroom, a bigger stall, for example. It actually gets very granular. The height of the toilet paper, for example, is in the regulations. You've also probably seen the handlebars. That I'm just continuing on to the bathroom example in the stalls to allow people to get on and off a chair. But it also extends beyond to people with visual impairments, hearing impairments. So it really is the entire panoply of what could constitute a disability in an individual to ensure that they have appropriate and necessary access as someone who doesn't have that disability. And fundamentally, a great idea. I think we could all agree. The challenge is, as part of the statute, the Americans with Disabilities Act, it creates what are called private attorneys general. And by that, I mean it enables private attorneys like myself to bring suit under the act to enforce its protections, but to recover attorney's fees and costs in doing so. And so that's really what's brought us to our discussion today, Darren, is that we have a whole host of these private attorneys general, individual attorneys who bring these suits primarily to secure fee recoveries, not necessarily because they have an altruistic intention.
Yeah. So, and just to kind of, in my mind, kind of clarify that my understanding is that existing spaces had to make accommodations. Obviously, if you're building something new, the code now is to code. You'd have to do whatever the code is. I'm assuming that the code includes these wider doors or ramps or whatever the accessibility items might be. Um, but is that am I on the right track there as far as what the
You
scope of the.
you are. So any new building certainly has to comply. There is, if you were constructed before 1992, you are grandfathered in, subject to having made any substantial modifications since that time. So if you have a building that's pre-1992 and you haven't done any remodeling, you don't necessarily have to do so to comply with the act because frankly, it could be financially prohibitive. However, if from 1992 forward you have engaged in substantial modifications to the premises, then you need to bring them into compliance with the act.
And is substantial, is it a dollar amount or is it actual an area of work, or how is it determined what's substantial?
It's a good question. There's a number of variables to consider. A gut renovation, I think, would qualify as substantial, certainly, depending upon the scope of the renovations. It's really a reasonableness standard. So, as a general rule in the law, anytime we don't want to be precise, lawyers just come up with reasonable. What a reasonably prudent person would do is the standard. And then a court is left to consider various facts that are particular to that case and make a determination as to whether it, in theory, objectively satisfies that reasonableness standard. So, to your point, a dollar value is a consideration. If you're making $1 million in renovations to a smaller restaurant space and you don't bring it into compliance with the ADA, I think we could qualify that as substantial. However, if you're an amusement park, although the amusement parks usually bring this into compliance, so it's not a good example. But if you're a mansion, you're one of these historic homes in Newport, Rhode Island, for example, right? And you're not modifying them, you're grandfathered in, you're landmarked. You might make multi-million-dollar repairs to the premises, but it doesn't qualify as a substantial modification for purposes of ADA compliance necessarily. So it is very much fact specific to the particular location.
Got it. So within the realm of the law and your area of practice, can you describe some of the nuisance type claims or the suits you've seen brought in this area?
Sure. And that's coming back to these private attorney generals that I mentioned. There has been a 319% increase nationally in ADA litigation over the past decade. That is tremendous. In New York City alone, where I am, 2,200 cases were filed in 2023 alone, the last year we have data. And so what we're finding is because, as we discussed, newer buildings come into compliance by virtue of they're trying to satisfy the building codes, they're trying to satisfy the ADA. The architects know going in that when they're going to design the premises, be it a restaurant, be it a store, be it a hotel, they're going to ensure ADA compliance. So what we're left with are a lot of these legacy buildings. And in many instances, there has been some modification, not necessarily substantial. And what we're seeing basically are attorneys, again, who are after the fee recovery under the statute, seeking to sue. For example, we represented a Chinese delivery restaurant in Manhattan. The name alone would suggest there's no reason for anyone to come to the restaurant, right? I mean, it was effectively a storefront with a counter, and they will bring it to you. Yet it got sued because the ramp in the front of the store was not technically at the appropriate incline and therefore was arguably not wheelchair accessible under the act. We similarly had a case of another instance in Manhattan, a coffee shop, and the putative plaintiff was coming from Queens and sued this Manhattan coffee shop, claiming that it couldn't get to the bathroom downstairs. The plaintiff couldn't because there were stairs in the way and prevented them access. We pointed out to the court in this instance that there's a lot of coffee shops in Queens. There's really no reason to come into Manhattan for a cup of coffee. But also in that instance, again, this was a location that had been around, literally, the building was 100 years old. The bathrooms were located downstairs, and there was really no means to provide egress or ingress to that location. This happens nationally as well. We have situations with clients, real estate property, shopping malls, for example, are a big case. Handicap parking, you have to have a certain number of handicap parking places, as you may know. Again, ramps are a big issue. Handicap accessible bathrooms are a big issue. It really runs the full panoply. But if there was, in my opinion, a real general intent on simply assuring accessibility and compliance, send us a letter. Don't just sue. And there are certain attorneys who will send what's called a demand letter and say, we've been to the premises and these are the concerns. Please address them or we're going to sue. What we're seeing now is sue first, ask questions later, and that just raises the costs for everyone. It's very expensive to defend these cases, particularly because they're in federal court, because it's a federal statute.
Okay. So you're not you're not going to the local county courthouse. You're going to the federal court.
Correct.
And I'm assuming that escalates the cost, and that's part of the appeal for the reason to bring these. Is that what you're saying?
It is. It escalates the costs, certainly. It also creates a host of other challenges being in federal court. In many of these instances, for example, the lease between the tenant and the landlord provides that the tenant has to ensure compliance with local, state, and federal law. So now you're also creating some dissonance there. The tenant, regardless of their size, may think they're doing everything fine. They moved into this building expecting it to be compliant upon arrival. And they're going to look to the landlord and say, you leased me these premises that aren't compliant with federal law. The landlord is then going to look to the lease and say, yes, but you signed a lease attesting to the fact that you would ensure that compliance. And so now you've got another whole fight between the landlord and the tenant, which is unfortunate, particularly if it's a tenant current on rent. That's happening ancillary, where they're pointing the fingers at each other when the enemy's on the other side of the V, it's the plaintiff. There's also at times indemnification provisions where the tenant can arguably have an obligation to indemnify the landlord, which means not only be responsible for the cost of remediation, but also potentially be responsible for the landlord's attorney's fees and costs in defending the litigation. And so these costs just begin to spiral. And it's one thing if it's a big landlord and a potentially a big tenant, a national chain realtor, a triple net credit type tenant. I'm sure your listeners are familiar. But if it's a mom and pop shop or just a small store, obviously they just can't bear those costs. And they're willing to comply as best they can, but the costs of remediation, depending upon the circumstances, can be impossible. And one of the other challenges we have with these nuisance lawsuits is when you tell plaintiffs counsel, look, we just can't afford to do this. What you're asking us to do is going to cost hundreds of thousands, if not millions of dollars. They then require financial disclosures. And so you're now in a position where you're having to disclose personal and proprietary confidential information, your tax returns, for example, your profit and loss, your balance sheets, things that you just don't want to have out there to try to demonstrate that you don't have the financial wherewithal to correct things. And it gets much more cumbersome and expensive, of course, if you're in a big city. So again, I'm in New York City, trying to comply with New York City law, New York state law, the federal law, getting the permits in place, working with the Department of Buildings. If it's an issue with a ramp into the store on the sidewalk, you have to work with the Department of Transportation. It is an impossible undertaking, and as a result, a hugely expensive one. So what happens more often than not is these attorneys recognize that, these plaintiffs' attorneys, and they come in just looking to extract a pound of flesh. They want a quick $10,000, $20,000 settlement. $1,000 or so goes to the straw person plaintiff, and they take the rest. More often than not, they don't even care if you actually remediate the condition. They're moving on to the next target.
I was going to ask if these result in any kind of actual work being done, or if it's more a matter of just go away kind of a payment kind of thing.
And some of them will be very particular and require what's called injunctive relief to compel the landlord, the tenant, the defendants to remediate. But the remediation also is unwieldy. So these plaintiffs don't necessarily even visit the property. What actually happens is they express an intent to visit the property, but claim there's this barrier for them to do so. And that was originally upheld by the courts, right? If I can't access your property, don't make me come visit it first because I can't access it. So what the plaintiff's attorneys do is they send in what are called testers. And these are people who show up basically with a measuring tape, and they will measure the incline of your ramp. They will measure the width of your doors, the space between your tables or display cabinets, the height of your counter where your cash register is, the bathroom, all of these other issues. And then the complaint, and most of these complaints are cookie cutter complaints. They're copy and paste exercises that set forth the ADA, a state analog. So for example, Oregon, where you are, New York, all have state laws that are analogous to the federal law. And then there'll be a section that copy and pastes from their tester's report that says, oh, and by the way, the toilet paper holder is supposed to be at 36 inches. It's at 35 3/4 inches, and therefore you're not compliant. We saw one of the tables in your restaurant was shifted over to the left. There's not sufficient space between the two of them. You need to fix that. Some of these, again, not so difficult, but a ramp, again, in New York City, getting the permits to do that, the space on the sidewalk with everything else, nearly impossible. We've also seen in cities, not just in New York, where they allege an absence of handicap parking spaces, which you just don't find on city streets. So it's not even something that we're obligated to provide, but because these are cookie cutter complaints and they, like I said, they just file, they're not paying any attention. We've litigated against plaintiffs' attorneys who have literally filed hundreds of these cases in any given year. And then they just hope, like we've been discussing, to extract that pound of flesh and move on.
Is there any chance for the courts to recognize the nuisance part of this? I mean, obviously we've, there are the issues that exist, but if somebody has no intent of visiting a place where the business is not, not set up, I mean, is there a solution that from the court standpoint that doesn't require all of the expensive renovation and the cost, or is it pretty much this is the law, and if you go to court, this is what's going to happen.
The courts are taking an interest in this because it is clouding their dockets. I clerked for a federal judge a lifetime ago in Miami, and she was very sensitive to this. She knew the plaintiff's attorneys, she knew what they were up to, and as a general proposition, she didn't tolerate fools lightly. So she was not one to accept these cases unless there was a real good faith basis for bringing them. More recently, we're seeing in the Southern District of New York, which is considered one of the premier districts in the country, judges seeing it from a standing issue. So again, the plaintiff never visited the site. More importantly, the plaintiff has no intent of returning, right? So we had a case where the plaintiff ostensibly went to an office building, claimed they couldn't access it to have something notarized. Well, we argued they're not going to go back to that office building and they can get a notary elsewhere. There was no intent to return. They needed to notarize the document once. It's not like they're going to a restaurant consistently. And the court dismissed it. The judges are seeing these are clouding their dockets. I think a lot of judges at both the state and federal level already feel very burdened. There's a lot of judicial vacancies. They've got hundreds of cases on their dockets at a time, and they feel burdened by this. So in the Southern District in particular, to answer your question, we're seeing a lot of these judges seek to dismiss the cases, even on arguments we haven't made. I mean, we make a ton of arguments seeking dismissal of the case out of the gate where appropriate. And we've actually had judges come up with even another argument as a basis for dismissal. And so now we're seeing these cases being brought in state court because a lot of these plaintiffs' attorneys are now afraid of the federal court, knowing the judges are not going to be receptive to them. But it's a real challenge. And if you can't get out on a motion to dismiss, right, when the complaint's filed and you have to go through discovery, it's incredibly one-sided. We're not really interested in what the plaintiff has to say, right? They're going to allege that they have a disability, whatever it may be. And again, there's no dispute that people with disabilities should be able to provide it access. It's the manner in which these plaintiffs' attorneys are trying to achieve that. But the flip side is the tenant and the landlord, they have incredible discovery obligations. They have to submit all of their building plans for when they actually did the construction. We've had to submit building plans that date back to 1912. Go back to the New York City Department of Buildings and get the original plans for when something was constructed, plus all those plans for remediation like we discussed, plus the possibility of financial information, sales information. So you're producing a host of documents, all of which has to be reviewed by your attorney at cost before we can produce them. Then the plaintiff's attorney is going to review at their cost, all to hopefully just get out on summary judgment or try to settle. But the problem is when you settle, they then sense that blood in the water, and they're always coming back for more.
Yeah. So are there any steps you can recommend that landlords and tenants, pay attention to or to try and minimize the risk that they face with this?
The best thing that people can do is actually engage in ADA compliance planning. And there are companies out there which will come just like the testers do, and they will assess the premises. They'll bring their tape measure and they will say to you, these are the compliance issues that can be addressed. And this is an estimate for the cost for remediation to get out ahead of it. It really is going to, again, be very location particular. A big shopping center, for example, probably a little bit easier to address than a smaller store, which just doesn't have the space internally to navigate a wheelchair or otherwise. We're also finding, and this is not a physical issue, but websites. In certain jurisdictions, websites are subject to the ADA. So for example, the Third Circuit, Pennsylvania, Delaware, New Jersey, finds that the ADA applies to websites. Excuse me, doesn't apply to websites. By contrast, the Second Circuit, New York, finds that it does. And so it's something as random as that. If you have a plaintiff in New York, they can sue a company in Oregon for non-compliance with the ADA because in New York, it's supposed to a website is supposed to comply. And so the businesses in that regard, I think, are also caught off guard more often than not because, they're putting up this website. Maybe it's their 15-year-old son who figured it out. They think they've got this online presence, and all of a sudden they're getting sued. And we're seeing a lot more of those cases because they're easy targets.
Yeah, it's unfortunate. I know that, excuse me, that one of the beauties of the American legal system is that everybody has access, but one of the frightening things is everybody has access.
Exactly right.
Um, and It does not necessarily cost a lot to file a suit. But if you have to defend one, or God forbid you get a judgment against you, and plus the court costs, and if you have to pay the opposing counsel's attorney fees, it can be pretty spending. So on these these situations, is there a kind of a I don't want to say a range, but is there kind of like a number that you see that these things typically come in at? I mean, obviously we're talking about a spectrum of you know deficiencies that one can allege, but how are are there damages, or is it more a matter of just the repairs to the building?
It is more so. In theory, it's an intention to get what's called equitable relief or injunctive relief to compel the defendants, the property owner, and the tenant to remediate the premises to ensure compliance. So it's not monetary. The reality is, there's the monetary component again with respect to the costs and fees that the plaintiff's attorney is seeking to recover, in addition to a fee. It's called a plaintiff's fee award, where the plaintiff gets $1,000, $2,000, $3,000 just for participating. So that's again really where the challenge comes from, because more often than not, these plaintiffs' attorneys, they find some condition that's not compliant, and they think they've struck gold. We've had settlement conferences, interestingly enough, with plaintiffs' attorneys and a settlement attorney by the court in the federal courthouse in Manhattan, where we looked around and the federal courthouse was not ADA compliant. I mean, it's hard. There's so many the doorknobs, right? You can't have round doorknobs anymore, right? They're the handles, right? Again, fine. I get it, right? No one disputes that people with disabilities should have equal access. But there's all those little things that if you just tell us, we'll fix it. But again, sue first, ask questions later, we're now automatically incurring all of this additional costs. And it's unique. Under what's called the American rule, in litigation, each party bears their own fees and costs. So if you were to sue in England, for example, and you won your case against me, I would have to pay your fees and costs. And it's intended to be a deterrent against someone bringing frivolous claims. The winner gets to win, and they get to have their fees and costs paid by the losing party. Under the American rule, that's not true, unless there's a statutory or contractual provision to the contrary. And here we have that statutory provision in the Americans with Disabilities Act. And that's, again, really what's caused all of these nuisance suits to thrive. If it weren't for that incentive, that private attorney's general incentive, we wouldn't be having this conversation today.
It's interesting. I didn't realize that was the unique nature of the American system, the American rule. But I know that there's plenty of people I've talked with that said that's the problem. Because if you did have to pay the other party's legal fees, you might think twice about, especially if somebody's willing to fight, and I would assume if you're being sued and you feel like you could win, or that you stand a better chance of winning than losing, you would certainly want to go to fight. Especially if you knew that if you won, that the other party would bear the cost of your defense, or whatever your legal fees were. So, interesting.
That's exactly right. I mean, and to your point, on the one hand, it permits access to the courts, which is, I think, a foundational, issue in American democracy and jurisprudence. But on the other hand, I tell clients all the time, anyone could sue anyone else for anything at any time. I could, respectfully, Darren, I could file a complaint against you in federal court this afternoon, alleging a whole host of obviously untrue things, which you would then have the burden of showing were false in defending the action. And that's the problem. I tell clients all the time, and again, I do this for a living, litigation is the least efficient and most expensive way to resolve a dispute. And these days, unless you're well into 7 digits, particularly where I am on the East Coast, it's not worth the cost of the fight. Because even if you're right, it's going to cost a lot of money to prove you're right. And we have a lot of instances, and in ADA cases as well, clients get sued, they come to us, and on principle, they want to fight. And I explain to them that principle will be fleeting as soon as they get our first invoice.
Yeah, and I'll tell you though, I think the insurance community, the insurance companies have started to rethink their uh, settle ideas, and they've kind of, I think we're seeing a lot more of a willingness to fight, um, because they recognize the short-sightedness of just settling kind of promotes that, the next complaint kind of thing to come through because, wow, they settled for that, huh? Let's send them another one, kind of thing. And, and I suppose there's some sort of a cyclical nature to it too. If all of a sudden it's mold or whatever the topic of the day, ADA or whatever is you know, paying off, then there's probably a little bit of an opportunistic thought process for the attorneys that think like that. But yeah, interesting.
We have a client, a very large real estate owner throughout New York State. And she adopted that famous line from from Billions, excuse me. I won't curse, but what's the point of having FU money if you can't say FU? And so she defends first and asks questions later. She is happy to spend $100,000 or more defending litigation just to deter people so that the community knows that if they come mess with her, she's going to mess back. Insurance companies, you're right, are doing that. It's often hard to get coverage for ADA compliance suits because, as you probably know, most policies have an exclusion. If you're violating local, state, or federal law, they're not going to cover that. It's equivalent of a detentional act, so it's often hard to get coverage. Like I said at the outset, if we're notified of this and we could remediate, we send the letter, that I think is an altruistic intent. But if you sue us and we call to resolve things and your first comment is, well, it's going to be $20,000 to settle this because of our fees, when we know you filed a complaint that was a copy and paste, we know who we're dealing with. There's an attorney out of Miami, Florida, for example, I've dealt with a number of times. Back before the pandemic, when we had live court appearances rather than via Zoom, he insisted that his airfare and his hotel accommodations to come to New York were part of his fees and costs, and that the defendants should have to pay for those as well. It really gets to be pretty extreme, the demands that they're making. And like I said, they're going after the smaller players here because newer buildings, bigger buildings are compliant. So you have to go after the lower hanging fruit, which don't have the resources. And then again, you factor in the website issues, and it really becomes very challenging.
Yeah. Yeah. Scary stuff. Hey,
It is. It is as particularly for small business owners who we consider to be the backbone of America in this country. I'm a partner in a number of restaurants here in the city, small business owner. Obviously, I'm a partner in my law firm, small business owner. I see this regulatory environment that is really very destructive for small businesses, and I think the ADA certainly fits within that. You want to do right. You want to give everyone, like we said, access and protect your business interests while also recognizing a place of public accommodation and accessibility and the rest. But it can be so cost prohibitive. And when you get into, like we've been discussing, defending these suits and the costs involved, recognizing the plaintiff's attorneys are in it for the pound of flesh, it's challenging. We had another case. We had an expert opine that we couldn't make the remediation to the premises as requested. They wanted us to build a ramp, and we couldn't under the spacing restrictions on the sidewalk would not let us construct a ramp, and there was a basement underneath that had a tremendous amount of mechanical. And as a result, we just couldn't build a ramp. We had an expert opine on that. And there was another ramp next door. And the plaintiff's attorney complained that that other ramp, that was one of the bases that we couldn't build our ramp, wasn't compliant. We said, well, that ramp was approved by the DOT. It was approved by the DOB. It's been there for 10 years. They're the ones that determine compliance, not you. And he continued to press us and litigate out this case. We had to retain an expert, $30,000, $40,000, fight off as many motions, discovery. We had to be deposed. We had to fight off financial disclosures because, again, no one wants to open up their kimono in that regard. We got it dismissed. The judge granted us dismissal on summary judgment at the end, but it took about 2 years and $100,000 to win. And then you have to question as to whether that's the win. And again, we couldn't then go to the plaintiff's attorney and say, cut us a check. But if it had been the opposite, that would have been the first thing he would have asked from us.
Yeah. Interesting. Hey, Josh, if we could, I'd like to shift gears here for a second. As I mentioned to you before we started, by day, I'm an insurance broker. And as such, I work with my clients to assess risk and determine what to do with the risk. And there's three strategies we typically consider. We first look to see if there's a way we can avoid the risk. And that's not an option. We look to see if there's a way we can minimize the risk. And if we cannot avoid nor minimize the risk, we look to see if we can transfer the risk. And that's what an insurance policy is. It's a risk transfer vehicle. And as such, I like to ask my guests if they can look at their own situation. Could be your clients, the local laws, federal laws, the interest rates, whatever it is that you identify and consider to be the biggest risk. And again, for clarification, while I am an insurance broker, I'm not necessarily looking for an insurance-related answer. And so if you're willing, I'd like to ask you, Josh Bauchner, what is the biggest risk?
Well, the biggest risk here is getting sued by one of these serial plaintiffs with one of these attorneys who's just in it for the fees. To answer your question, I think ADA compliance planning, bringing in one of these testers like we discussed to assess the premises and make any determinations as to what's not compliant. Then do an assessment as to what the costs would be to potentially bring it into compliance. Is it something that you could readily do? Putting up the handlebars in the bathroom stall, for example, perhaps changing the front entrance door to provide handicap accessibility, or is it cost prohibitive? If the bathroom's downstairs and you can't install an elevator, there's really no way around that to gain access. And then the challenge becomes with respect to shifting that burden. The landlords are doing that, right? So in most lease agreements, most commercial lease agreements, the landlords are including an indemnification obligation where they're shifting the burden onto the tenant to both ensure compliance, remediate the premises in the absence of compliance, and if sued, pay for the landlord's fees and costs. The challenge is, again, the tenant doesn't necessarily recognize that obligation in the lease when they're signing on, and they certainly don't recognize what the costs that they're at risk of incurring are going to be if they are sued. And so unless they're a really big business, $100,000 hit to your bottom line could put you out of business. And then again, it becomes the domino effect. Great. So now they are out of business. They've shut down. They've got 6 more years on their lease term. They vacated the premises. Now the landlord's suing the tenant because they breached the lease. The landlord now has to find a new tenant to mitigate. It just creates a whole host of unintended consequences, all because, again, these serial filers think they're doing right.
Yeah. No, sad but true. But onward. Hey, Josh, where can listeners go if they'd like to learn more or connect?
Thank you for asking. Our website, it's Mandelbaum Barrett is the name of the firm. So it's MB, as in Mandelbaum Barrett, mblawfirm.com. And if you visit our website, we have quite a lot of information on just this issue, ADA compliance and nuisance suits, as well as all the other services we offer our clients.
Awesome. Well, Josh Bauchner, I can't say thanks enough for taking the time to talk today. I've enjoyed it, learned a lot, and look forward to doing it again soon.
Thank you. Thanks for having me. I enjoyed it as well, and happy to come back anytime.
All right. For our listeners, if you like this episode, don't forget to like, share, and subscribe. Remember, the more you know, the more you grow. That's all we've got this week. Until next time, thanks for listening to Commercial Real Estate Pro Network's CREPN Radio.
You're listening to CREPN Radio for influential commercial real estate professionals. For more information on this or any of our guests, like us on Facebook, CREPN Radio.